Court does call the case. People, State of Michigan versus Justine Cheetum.
Good morning, Your Honor. Marie Caroline System on behalf of people.
Good morning, Rob Jacob on behalf of Destiny Cheetum, who's on Zoom, and we appreciate allowing her to be on Zoom. Destiny, would you state your name for the record, please?
Destiny Cheetum.
This courtroom opens quietly, but make no mistake. What you're about to see is a rapid-fire snapshot of how criminal justice actually operates day to day. Not television, not dramatized scripts. This is real court, real consequences, and real people making decisions that will follow them for years. Today's docket moves fast, but every ruling carries weight. Waivers, bond decisions, dismissals, guilty pleas. Each one is a strategic fork in the road. You'll see defendants choosing whether to fight or fold. Attorneys making calculated moves to protect their clients. Judges balancing efficiency, safety, and fairness, all under time pressure. And in several moments, you'll hear language that sounds procedural, but quietly determines someone's freedom, their record, or whether they even go home that day. As we move through this hearing, listen closely to the phrases judges repeat: waiving rights, bound over, unable to proceed. These aren't just formalities, they're checkpoints in the justice system. Miss one, and your case changes instantly. And here's the bigger question to keep in mind as you watch. When cases move this fast, is justice being served or just processed? Stay with us, because some of today's most revealing moments come when the court seems almost routine.
Okay. Do you have a camera, Destiny?
No, I don't. My screen is shattered.
Okay. I know her voice, Judge. That's her. What we'd like to do
Or
today.
either you're going to waive.
Yes, Judge.
Does either party have an objection to her not having a camera?
No. Do you object to her not having a camera?
No,
All right, very good. All right. It's going to be a waiver.
Yes.
Ms. Cheetum,
Yes.
you understand that you're waiving your right to a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes.
You understand you'll not have that hearing today and you'll proceed to circuit court for further resolution?
Yes.
People also waive their right. Preliminary examination having been waived, defendants bound over to circuit court on a single count.
Judge, we acknowledge the information waive its reading. My client would stand mute.
Defendant having waived formal reading, standing mute. Court will enter not guilty. The pretrial will be set for July 8, 2025, 1:30, Judge Conkey.
Thanks, Judge. Judge, we do appreciate allowing my client to appear by Zoom. Thank you.
No problem. Yes, just one moment. Bond will continue in this matter.
Thank you, Your Honor.
Court does call the case. People versus Sean ODM.
And then on behalf of people, Your Honor.
Good morning, Your Honor. Good morning to the honorable staff. If it please this court, Brandon Bird, PA 3734 on behalf of Sean Odom. Mr. Odom, can you please state your full name for the record?
Sean Martell Odom.
Thank you.
You up?
Today's the date and time set for preliminary examination. At this time, people are unable to proceed as to count one, and would ask that count two and the added count three on the amended complaint be remanded to district court.
When you hear people are unable to proceed, that's not just a delay, it's a crack in the prosecution's case. Prosecutors carry the burden of proof. If they can't move forward on a count, it often means missing evidence, unavailable witnesses, or strategic recalculation. And here, that leads directly to dismissal of count one. But notice what doesn't happen. The case doesn't disappear. Counts 2 and 3 remain alive, and the defense immediately raises an issue: lack of notice of the amended complaint. That matters. Due process requires that defendants know exactly what they're being charged with before entering pleas or waiving rights. The judge pauses proceedings to fix that problem. This is the court protecting the integrity of the process. No shortcuts, no guessing. The defense must have the document, review it with the client, and only then proceed. This moment shows the balance court's attempt to strike efficiency without sacrificing fairness. But it also exposes how easily miscommunication can derail progress. Ask yourself this: if a charge can be amended this late, how confident would you feel about fully understanding your exposure at any given moment?
All right. As to the amended count 3, the domestic violence second offense, you waive formal reading of that charge, counsel, and your client pleads not guilty.
Yes, Your Honor.
All right.
Respectfully.
You need a copy of it?
Right, I never seen the amended complaint, Your Honor.
Did you want me to pass it so you can go over that with your client?
Yeah, let me please.
Okay.
Your Honor.
So I'll pass the matter. We'll take him back, then you can go run and talk to your client. Call it back up. Court does recall the case. People versus Sean ODM.
Alexander, on behalf of the people, Your Honor.
Yes, Your Honor. Brandon Byrd on behalf of Sean Odom. Mr. Odom, can you state your name for the record again?
Sean Martell.
Thank you.
You're welcome.
All right.
Yes, Your Honor. We did get a chance to discuss this with my client. Understandable. We're gonna wait a formal reading, stay on mute.
All right. Court will enter not guilty plea as to that count 3. Maintain his plea of not guilty as to count 2. Count 1 will be dismissed. I'll set a pretrial on counts 2 and 3 for May 28, 2025, 9 a.m. That is Judge Perry at the 15th District Court on the misdemeanor charges. All right.
Permission to address bond, Your Honor.
Figured you would. Go ahead.
Respectfully, we got the misdemeanor that was dropped today. It's the same complaining witness that's on this case. That's just been dropped at the domestic violence second. So I'm not sure really how far this case is gonna go, but that's something we'll see in district court. Essentially, my client's been in jail for since March.
About a month.
About a month. Roughly about a month now. Now it's pushed back almost 2 weeks, Your Honor, for 2 misdemeanors, which essentially could potentially be probationable, or
Yeah.
it's almost like he'd be serving a sentence if he stays in jail too much longer. One of these is a 93-day misdemeanor. I understand the other one's up to a year. But respectfully, we're gonna ask for a personal bond in this matter. He understands no contact with the complaining witness. He doesn't want any contact with the complaining witness. My client doesn't want to be sitting in the jail cell like.
Well,
is right now.
he had a personal and then messed that up.
Understandable, Your Honor, but now we're dealing with a whole new set of situations in which my client's been sitting in jail for a month now, almost a month.
This is where courtroom reality hits hard. Defense counsel is making a classic but powerful argument. Pretrial detention shouldn't quietly turn into punishment. When someone sits in jail for weeks on misdemeanor charges, especially probation-eligible ones, the system starts edging into unfair territory. The attorney frames it carefully: time served, employment risk, proportionality. These aren't emotional pleas, they're legal pressure points. Judges are required to consider whether continued detention is reasonable, especially when delays stack up and cases get pushed back. But then the prosecution responds with devastating context: prior bond violations, repeated contact with the victim, allegations involving a child. That changes everything. Public safety becomes the dominant concern, and the court's tone shifts instantly. This exchange shows why bond hearings are often the most consequential moments in a case. They're not about guilt or innocence, they're about trust. Has the defendant earned the court's confidence? And here, the answer is clearly no. Who do you think carries more weight in moments like this? The presumption of innocence or the history of prior violations?
And I'm pretty sure a month in jail gives you a lot of time to think about where you want to be and where you don't want to be, and how you operate.
Onto the people. I want to go back to work.
Severe concerns that he can follow court orders. He did pick up that bond violation where he was in contact with the victim while out on bond and had another assaultive incident with her. And in this case, he had an assaultive incident with her and her child, giving the child a black eye. I also think that because he's currently on probation in 15 for leaving with this same victim. So I don't believe he can keep himself from being in contact with her. And I have great concerns for her safety and her child's, given the facts of this case and his previous history with numerous dismissed DVs and convictions on DV.
Anything else, Counsel?
Respectfully, Your Honor, my client went to the police station. He went to the police station and made a police report in Ann Arbor. That's one of the reasons for the contact.
So right, but here's what ended up happening. He had a personal bond. He didn't follow the conditions. He then came into custody, was arraigned, and the bond was set at where it is now. As a result of his failure to follow the conditions. And then that is even really outside of the other stuff that the prosecutors indicated regarding the other contacts and other complaints that he has with the victim in the case. What I'm gonna do is I'm gonna deny your request to reduce his bond. You can take it up with Judge Perry, but at this point, I'll do it that way.
Thank you for hearing me out. Your Honor.
This ruling is firm, and it's grounded in a principle courts take very seriously. Past behavior predicts future compliance. The judge doesn't just deny the bond reduction, he explains why. Prior violations, contact with the victim, and ongoing probation issues all stack against the defendant. Importantly, the judge redirects the defense to another judge for review. That's not a brush-off, it's procedural reality. Different judges oversee different stages, and bond can always be revisited, but only with a stronger showing. This is a reminder that courtroom advocacy isn't about one speech, it's about building credibility over time. Once a defendant burns trust, regaining it becomes exponentially harder. From the outside, it may feel harsh, but from the bench, the calculation is simple. If release creates unacceptable risk, detention continues. Do you believe the system gives enough second chances, or are some mistakes simply too costly once made?
Court calls case People versus Jaylen, Kendrick.
Ally Zend on behalf of the people, Your Honor.
Oh, boy. Oh, no.
Good morning, Your Honor. Student Attorney Kara Rosengren requesting to practice under Michigan Court Rule 8.120 under the supervision of Assistant Public Defender Hannah Apple on behalf of Mr. Kendrick. Could you say your name?
Jaylen Kendrick.
So where are you from?
Me?
I know where he's from. I got all that information. I know where Apple's from. Yeah, you.
I attend Cooley Law School, Your Honor.
You do?
Yes.
Oh, a Michigander or you?
Yes.
What part?
I currently reside in Dexter, Your Honor.
So even a Washtenaw County, Michigan.
Yes, Your Honor.
Where are you originally from?
Oakland County, Holly, Michigan.
Yeah, kind of blew it there. Okay. Where'd you go to undergrad?
Western Michigan.
So you just never left the state?
I actually lived in Chicago for 15 years, Your Honor, so
Did you?
Mhm.
Didn't like it?
loved it, but came back for my husband's job.
Oh, he's to blame. All right. Permission to practice is granted. Welcome aboard.
Thank you.
This moment brings a rare tonal shift, humor, warmth, and humanity in an otherwise rigid environment. A student attorney steps forward under supervision, and the judge engages personally. These exchanges matter more than they seem. They remind us that courtrooms aren't just about punishment, they're training grounds for future advocates. But the professionalism snaps back immediately. Count 1 dismissed, count 2 proceeds. Bond continues. No celebration, no delay. The system keeps moving. This contrast is telling. Compassion exists in courtrooms, but it never stops the machinery. Judges can joke for 30 seconds, then decide someone's legal fate in the next breath. And that's the tension that defines real court, humanity operating inside a system that cannot slow down. As we move forward, watch how often that balance appears, and how quickly it disappears when stakes rise again.
In Your Honor, today's date talks about preliminary examination. At this time, people are unable to proceed as to count 1 and would ask that count 2 be remanded to district court.
You're moving to dismiss count 1.
Yes, Your Honor.
People being unable to proceed as to count 1. Count 1 is dismissed. I'll maintain the defendant's not guilty plea as to count 2. Pretrial in this matter will then be set for
Judge Washington.
June 9th, 2025, 9 a.m. That is before Judge Washington. Thank you.
Thank you.
Bond will continue. Thank you. Court does call the case People versus Quinard Sanders.
Good morning, Your Honor. Alex Warren, Green on behalf of Mr. Sanders. State your name.
Quinard Sanders.
I have a plea form in front of me.
That's correct, Your Honor. We are going to be proceeding on a guilty plea. Mr. Sanders is currently executing a sentencing judge waiver and the advice of rights form for the court.
This is a decisive pivot point. Unlike earlier defendants who waived hearings or stood mute, Mr. Sanders chooses certainty over risk. A guilty plea is not an admission made lightly, it's a negotiated outcome. In exchange for pleading guilty to attempted resisting and obstructing, the original count is dismissed. That's the trade. Reduced exposure, clearer sentencing boundaries. Listen closely to how the judge conducts this plea. Every question serves one purpose: to ensure the plea is knowing, voluntary, and intelligent. If any of these boxes aren't checked, the plea can be overturned later. That's why the judge slows down here. Rights are listed, appeals are waived, no promises beyond the agreement are confirmed. And then comes the factual basis. Sanders admits he ran. That single statement legally supports the charge. No drama. Why, no embellishment, just enough truth to satisfy the law. This raises a key question. If you know the evidence is strong, is accepting responsibility the smarter move, or does pleading guilty still feel like surrender, even when it limits damage?
All right. Plea form indicates that the defendant will be pleading guilty to an added count 2 of attempted resisting and obstructing a 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. There's further the agreement of no delayed or deferred sentencing. That's the court's full understanding of the agreement.
That's our understanding, Your Honor.
Is that correct, counsel? All right, very good. May I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give the truth, the whole truth, and nothing but the true self you got? State your name.
Quinard Sanders.
All right, sir, it is this court's understanding that you are going to be pleading guilty to the charge of attempted resisting and obstructing a police officer. That's a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. Do you understand that, sir?
Yes, sir.
You understand also that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 1482 District Court. You understand that?
Yes, sir.
All right. Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
Well,
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
no, Your Honor.
I'm sorry.
No.
Has anybody threatened you or forced?
No.
You're doing this voluntarily
Yes, Your Honor.
of your own free will?
Yes.
And because you believe that you're guilty of this offense?
Yes, Your Honor.
On the date of December 17, 2024, at the location 500 West Cross Street, City of Ypsilanti, Washtenaw County, State of Michigan, did you come into contact with a police officer from the Ypsilanti Police Department?
Yes, Your Honor.
What happened?
He asked me to get in the car and I ran.
I'm sorry?
He asked me to get in the car and I ran.
May I have what do, Your Honor?
Pardon?
Ma'am,
Yeah,
what-
go ahead.
Mr. Sanders, you were approached by a uniformed officer on that date at that location, right?
Yes.
And that officer informed you that he was investigating a crime, right?
Yeah.
And you began walking away, right?
Yep.
And he told you to stop.
Yep.
And you ran.
Yes.
Okay. You knew he was a police officer, right?
Yes.
Okay. You don't dispute that he was acting pursuant to his lawful duties, do you?
Nope.
All right. Your Honor, I believe that lays a factual basis.
As the court complied with the court rule, would it be proper to accept this defendant's plea?
Defense is satisfied.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 1482 probation.
With those words, the case fundamentally changes. Trial is gone. Arguments are over. What remains is sentencing and consequence. The judge orders a presentence investigation, which means probation will now dig into the defendant's background, criminal history, employment, substance use, family obligations. That report will heavily influence sentencing. This is where many defendants underestimate the process. Pleading guilty doesn't end scrutiny, it redirects it. Everything you've done before this moment now matters more than ever. Bond continuing here is also notable. The court sees no immediate reason to detain Sanders further before sentencing. That's a quiet signal of measured trust, conditional but present. Efficiency-wise, this is the system working as designed. Evidence supports the charge. Defendant accepts responsibility. Court resources are preserved. But from a human standpoint, it's sobering. One decision, one run from an officer, and now a criminal conviction follows you forward. Do you think plea bargains serve justice, or do they simply keep the system from collapsing under its own weight?
Sentencing will be
May 28th at 10 a.m.
May 28, 2025, 10?
Yes.
10 a.m. before Judge Barr. Bond will continue.
Thank you, Your Honor.
All right, thank you. Thank you, Mr. Sanders. Court does call the case of the People versus Stephen Watson.
We're ready in this matter, Your Honor.
Good morning, Your Honor. Katie Rispersky.
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Stephen Watson. Mr. Watson, please state your name for the record.
Stephen Watson.
All right. What are we doing?
Your Honor, as the court is aware, this time and place scheduled for preliminary examination. People are able to proceed this morning. I would anticipate a motion to dismiss the felony. I would be seeking a remand on misdemeanor, but I seek the court's guidance as well. It's charged as a DD first, and it should be a DD second. I apologize to the court of counsel that I do not have a DD complaint prepared, but I could move to add a count 3 of DD second or amend count 2, whatever the court's preference is.
Oh. And Ms. Zenda is like an expert
I mean,
at getting those amended complaints done. And so I think Ms. Zenda might help you out
I
there.
think she's doing the things right now.
Oh, is she? Okay, see? So what I will do then is, and should we do that? I mean, it's my case, so I'll remember, but should we do that as count 3 or just amending count 2?
Just amend.
Count 2, you think will work? Okay. So we'll just amend count 2 to reflect into DB second.
Wonderful. Thank you.
And you're waiving reading on that?
Yes, Your Honor.
And I'll just indicate that we'll maintain his plea to the amended count 2 in this matter of DB second. Count 1 would be dismissed as people are unable to proceed. I'll set a pretrial in this matter for
May 19th at 1 p.m.
May 19th, 2025, 1 p.m. That's before me.
Thank you, Your Honor. May we address the issue of bond?
Sure.
Honor, my client was out. He had difficulty, and I believe there were issues with
Positive drops.
with positive testing. My client does have employment. He is hoping that the job is maintained for him, but he does not think it will be maintained for too much longer past today's date. The felony charge was dismissed because there is no complaining witness. I expect there will probably not be a complaining witness at the court date as well. Based on that, Your Honor, I'd ask that my client's bond be returned to its previous state. My client has indicated that he will follow all of the strictures of the court. He has learned the importance of not indulging in drug use during any time period. He's asking that he be allowed to have his bond reinstated. The time he has sat in has taught him a valuable lesson.
The problem is that he was testing positive. That's part of the problem.
This exchange cuts straight to credibility. Employment, family, and intentions all matter, but compliance matters more. The judge isn't dismissing the defendant's struggles. She's weighing them against repeated failures to follow court orders. Positive drug tests and missed program requirements aren't technicalities. They're indicators of risk. Courts don't just punish past behavior. They try, imperfectly, to predict future outcomes. And here, the prediction isn't encouraging. What's striking is how the judge leaves the door open. She denies release now but signals conditional reconsideration. That's judicial leverage. Show me structure, show me accountability, then we'll talk. This is the system offering one more chance, but not blindly. Compliance isn't optional, it's the price of freedom. Here's the question that matters. Should courts prioritize rehabilitation when trust is already broken, or does accountability have to come first?
The other part of the problem is he was supposed to then start CCOP and he didn't appear.
I talked to the agent and working a lot of hours. Told me to come to court and signed up for the COP or whatever, because I can do intensive outpatient treatment.
So, Your Honor, he did have contact. The problem was at the time, he was working a lot of hours, and he had gone past the time when he should have been reporting. He did speak to the agent. Agent told him to come to court, and then he could start getting into the program then. It's not that he doesn't want to. It's not that he intentionally tried to avoid what needs to be done. He set priorities with working and maintaining himself and his family. And that priority, as it turns out, was the incorrect. He has learned then what the priority should be. And again, it's not like he didn't make contact at all. He did do that. He was working. He'd like to continue to maintain that employment.
Okay, I don't need a response from people. I'm gonna, at this moment, deny your request. I'll look at it again come the 19th. Since it's coming back before me, it's just less than 6 days from now. I'll take a look at it. I would like to see something that's gonna keep him on track. Because if he continues to use, doesn't do anything, we're gonna be right back in the same boat. So
I'm not going to use, my job is at risk, and I'm full of positive drops, and I can guarantee that. I'm just trying to get back to work. My job is.
No, I hear you.
Yeah, Judge Simpson,
But
I really learned my lesson. Like, I understand like the importance of not dropping dirty and things like that. And I have learned my lesson. I don't need to be in here. If you give me a chance, I won't let you down. I really just trying to get back to work. And
how many times do you think I hear that?
a lot, Your Honor, a lot. And yeah,
So tell me what makes you different.
Because I got 6 kids, I got a lot of things going on, and I'm not a person that constantly gets in trouble. I'm done with the drug use. My system is clean, so you have no problems with that. So if I drop today, drop next week before I come to court, everything could come back the same. And you got my word on that. Like,
so if I were to let you out, if I change my mind and I were to let you out, you test dirty or don't follow anything,
I would do the time in jail. But I'm not
do it right now anyway.
Yeah, but I'm not trying to do that. But what I'm saying is I come back and plead guilty to everything. I'm just really trying to get back to work, and you won't have no problems out of me after today.
You need to get yourself set up with some type of outpatient.
Yeah, and that's what I'm saying. If I go to community corrections today, I can sign up for the intensive outpatient treatment, so I can be able to get on the right track. But there will
tell you what, I'm gonna at this moment deny your request. However, if council would contact community corrections, see what they need, I will consider an order to release him with some strict compliance in their program.
This is conditional mercy in its purest form. The judge doesn't accept promises. She demands infrastructure, treatment plans, supervision, accountability. Words alone don't unlock the jail door. Notice how the judge frames it. Not if I feel like it, but if community corrections has something in place. Responsibility shifts outward. The system requires proof before trust. This moment highlights a critical truth. Freedom in criminal court is often transactional. Compliance buys opportunity. Failure closes doors. For the defendant, this is a narrow window. One last chance to align actions with words. For the court, it's risk management, not optimism. If you were in the judge's seat, would you take that risk or keep the door shut until certainty replaces hope?
See if they have something in place for you. Okay. Oh yeah. Please.
So I'm not saying no forever, but I'm gonna need something that.
Thank you, Your Honor.
Thank you.
Thank you, Judge.
Okay. Court calls the case, People versus Timothy Stevens.
Alexander, on behalf of the people, Your Honor.
Oh, you're back.
Student Attorney Kara Rosengren, on behalf of Mr. Stevens, Your Honor. Say your name.
She's back.
Stevens.
Your name, sir?
Timothy Stevens.
Thank you.
In your date concept for preliminary examination, at this time, the people are unable to proceed as to counts 1 and 2, as that count 3 be remanded to district court.
So you're moving to dismiss counts 1 and 2?
Yes, Your Honor.
Counts 1 and 2 are dismissed. I'll maintain the defendant's not guilty plea as to count 3. Set a pretrial in this matter for
June 5th, before Judge Rush
June 10th, you said? 5th, 2025, 10 a.m. I'm sorry. 10 a.m. before Judge Freshour.
Thank you.
Yeah, bond continue.
Thank you.
Thank you. Court does call the case, People versus Deborah Gilmore.
Katie Rosemersky for the people.
Yes, Your Honor, Brandon Byrd on behalf of Deborah Gilmore. Ms. Gilmore, can you please state your full name for the record?
Deborah Gilmore.
Morning, Your Honor. People are unable to proceed at this point.
All right.
Respectfully request dismissal, Your Honor.
Your Honor, request a remand for this meeting.
All right. People being unable to proceed as to count one, that is dismissed. I'll maintain the not guilty plea as to count two. I'll set that for a pretrial on
June 9th at 9 a.m. for the Washington.
June 9th, 2025, 9 a.m.
Yes.
9 a.m. before Judge Washington.
Thank you, Judge.
Thank you. Bond will continue. Thank you. Okay. Court does call the case, People versus Brandon G.
And is it on behalf of the people, Your Honor?
Assistant Public Defender Ben Dunawith on behalf of Mr. Gvers, who is standing to my right. Brandon, would you state your name for the record, please?
Brandon Gvers.
Your Honor. Yes, Your Honor.
So you're waiving your right to a preliminary examination?
Yes, sir.
You understand that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
You understand that you'll not have that here. You'll proceed to circuit court for further resolution.
Yes, sir.
People also waive the right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on count one with two following.
Your Honor, we will waive the formal reading and stand mute.
Defendant having waived formal reading, standing mute, both counts. Court will enter a not guilty plea. Pretrial will be set for July 17, 2025, 1:30. Judge Slay.
Your Honor, could I address Ron briefly?
He's out.
He's out, but he's on a tether, and the complaining witness apparently lives thousands of miles away. So I don't think the tether serves any purpose, and we'd ask the court to take it off.
Your Honor, I just have concerns given the facts of this case. I'll leave it in the court's discretion, but I just have concerns given the highly valued factors in this case of strangulation. But she does reside out of state, Your Honor.
They're not in any proximity to each other.
No.
It's just a GPS location track.
I would ask the court, if we don't leave the tether on until tomorrow, she is in state today. So I would have concerns for her safety while she's here and ask if the tether be removed tomorrow when she's back out of state.
His bond will continue. What I will do is I send an order. We'll remove the GPS tether effective Friday.
Yes, sir.
Okay.
Thank you.
Thank you, Judge.
Yes, sir.
The cases of the People versus Brandon Carter. Didn't mean to wake you. No.
Lauren Brown, Deputy Chief Public Defender appearing on behalf of Mr. Brandon Carter. It has been discovered that Mr. Carter has been lodged at the Monroe County Jail.
Oh.
But he is unable to make this court date. He'd love to, but
So he's currently lodged there?
that is my understanding.
Is that also the people's understanding?
My officer in charge.
Okay, so do we know how long he will be there?
No, I do not have that information as of yet, Your Honor.
We don't.
All right, well, why don't I do this then? Hey, I'll find good cause adjourn the preliminary examination. I can set it for the 3rd or the 24th of June, which would 24th. June 24th, 2025.
You don't have the
Then this is all messed up. Why? Oh, I can't. You're right.
Correct. You have the 17th in the afternoon.
I have the 17th of,
Yes, of June, because of Juneteenth, so it's PMs.
oh,
So June 17th?
June 17th, 2025 at 12 noon.
Now, would the court consider just a nominal bond in the event if he were to be released, at least he wouldn't drift off into the ether because he wouldn't necessarily have notice of this date? Obviously, we will work to rid him, but I don't know. He may get out of Monroe County Jail between now and June 17th.
Any response?
A very, very nominal bond, Your Honor. Like $10?
Brown, when have you ever known me to set a $10 bond? I think I did once. Still haven't seen that person. I'll set bond in both cases at 1,010%.
This final bond decision may sound lighthearted. There's even humor around the idea of a $10 bond, but it carries real weight. Bond isn't about punishment. It's about ensuring return to court. Here, the judge finds a middle ground, low enough to allow release, high enough to maintain accountability. Judges constantly walk this line. Too high and bond becomes detention by another name. Too low and court authority erodes. This ruling reflects pragmatic control rather than emotion. It's also a reminder that every defendant on this docket is being evaluated individually. Same courtroom, same judge, completely different outcomes. That inconsistency isn't randomness, it's discretion. Do you think judicial discretion creates fairness or unpredictability?
Thank you. Thank you.
Today's docket shows the criminal justice system exactly as it functions: fast, procedural, and relentlessly consequential. We saw waived hearings that accelerated cases into higher courts, charges dismissed not because of innocence, but because prosecutors couldn't proceed, guilty pleas that traded uncertainty for finality, and bond decisions shaped less by promises than by patterns of behavior. Judge Simpson consistently applied the same principle across cases. Rights matter, safety matters, and compliance determines outcomes. Defendants who followed rules preserved options. Those who didn't lost leverage. That's the unspoken currency of court, credibility. None of these cases were resolved by emotion alone. They were resolved by records, conduct, and procedure. And that's both the strength and the tension of the system. One, if you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.